I'm Frozen Until I Can Get Up Company presents.
We've been here 200 years, and still the army won't take queers. High taxes have me nearing tears, but we can bomb the world.
The Americana theme park. Take a walk through history and witness the making of a nation.
First, we take a couple of repressed pilgrims, enslaved blacks, throw in some Euro trash, shake thoroughly, and voila! A country!
Our first step, Frontierland.
The Indigenous Peoples Court is now in session. Judge Haywood Jablomi presiding. Your Honor, the white man has stolen our land. In return, he gives us bingo. Who is Bingo, Your Honor, and what does he want from us? I have seen his name on the marquee at the Polish American Club, so he must be very big medicine.
And you won't want to miss the thrill of Adventureland. For just $69,000, you can take the Whitewater Shaft Ride. Follow your own special prosecutor through a confusing maze of paperwork. Then cool down in the Ted Kennedy Water Park.
Ladies and gentlemen, the ride is about to start. Please unhook your seatbelts and keep your head in my lap. Keep your hands in the car.
Now that's family fun.
Always buying, often lying to get reelected. Double talking when they're squawking, these guys have perfected.
And in Fantasyland, you'll hear about a middle-class tax cut and a balanced budget. Then visit the haunted White House and drop in on Ulysses S. Grant at a state dinner.
Let me tell you something. That Robert E. Lee was a Now give me a beer.
Watch Gerald Ford greeting international leaders. And for the kids, there's Liddyland.
Break-ins where his work, now he's a talk show jerk.
G. Gordon gives advice on parenting.
Hey, kid, come in. Now behave, or I'll break into your treehouse.
And no trip to the Americana theme park would be complete without a visit to the Hall of Incompetence. Hear Mickey reading from the Packwood Diaries.
Then I bent her over the copier, then Xeroxed her jugs on congressional letterhead. Oh boy!
Clinton's mastery of language.
I have nothing else to say. We did the stories. It's not true.
And Dan Quayle as Dumbo.
The question is whether we're going to go forward to tomorrow or we're going to go past to the back. We don't want to go back to tomorrow. We want to move forward. And the future will be better tomorrow.
Who's the guys who spend their time screwing you and me? CONGRESSMEN, congressmen.
Our tongues are forked.
Congressmen.
We're passing pork.
Oh, how they love to raise our taxes high.
High, high.
CON.
As in criminal.
GRE.
Just add ED.
SSMEN.
Welcome to Facts or Frauds. Now let's head to Washington State for Sovereign Blatt and his quest for freedom.
And Mr. Blatt, good morning.
Good morning.
And your criminal charge was dismissed on Friday, is that right? Thursday.
I don't know. Okay, well, thank you. How come I wasn't notified?
Well, that's not what you're here for today. You're here for the traffic infraction. That's what it's for. I don't know.
I thought this was a motion hearing.
It was going to be, but the state made a motion to dismiss your charge.
Okay. So now it's going to be contested.
Yeah, I'm waiting for your file to open up here. Sometimes our technology lags, so I'm waiting for it to give me access to your file.
I didn't come prepared to contest the infractions.
Well, that'll be easy because you can tell me whether you have insurance or not. But hold on a second.
Sure.
Let me just explain. Failure to transfer title, the trip permit, and the driving suspended charges, which are all criminal charges. And those are the ones that you'd filed all the pleadings on, which I've read all your pleadings.
Okay. You have any comments on it? Just curious.
I'll give you my comments here in a moment.
And I believe the police report states that I did produce my insurance, but it took me a while to find it.
Do you happen to have a copy of it with you?
Yeah.
Yes, you.
Should I approach?
Yeah, please.
To the middle of the big paragraph. Oh, it's on the last paragraph.
Right. And do you have a copy of whatever you showed the officer by way of the insurance proof?
Yes. Oh, it's on my phone.
Yeah, that's fine. Do you have your phone with you?
Yeah, but I let somebody, one of my employees, take care of that. And he, whenever I need my insurance, I ask him where it is. But it'll take me a while to find it if you need me to.
Well, see if you can find it. I'm reading this.
Okay. I'm bringing it up.
Okay, great. Okay, so this is showing insurance for somebody, not you, for a car. I don't think it's the car it's identified here. Okay, it could be the vehicle. Who's Thomas Harris?
He's the employee that takes care of that stuff. He registers the vehicles, gets insurance for them.
And employee of yours?
Yeah.
And what type of business?
Biodiesel. I'm building a gas station in Grand Mountain.
All right, and then the other thing to note here is that the insurance is purchased the day after the stop.
No.
Yeah, look at 411. Stop was on 410.
Well, I can call. I'm sure it wasn't because when I called him, he produced this instantly. So I can call him and get it.
And you saw that, right? You saw that it said effective 411.
Let me take another look.
I just called to say.
Yeah.
Thomas, you're on speakerphone. I'm in court right now. The criminal charges were dismissed, but the no insurance charge. Remember when I called you when the police stopped me and you sent me a copy of the insurance card? Well, the insurance card looks like it was purchased the day after the stop.
Oh, maybe it's just been the wrong one. Tell them that tell them we have a different insurance card. We've got so many vehicles here. It's crazy. There's no way to get an insurance card that quickly when I'm working like that. The only thing I could do was send you some proof of insurance that I had in my phone.
Okay. Yeah. All right.
So what did they say?
Well, you're on speakerphone now. I'm in court, and
I mean, you got to realize we're working around.
How could this possibly be purchased the next day? You didn't purchase insurance the next day, did you?
No. What they may have done is what they do is they renew the insurance every 6 months or so. And what happens is it automatically prints out ahead of time. And so what may have happened is they give us the card in advance, and then I get it online, and then I just put them in my phone. But I got so many cards in there that it's hard to find them.
Okay. I think that explains it.
Okay. Yeah.
Okay. Well,
if you need me, I can look up and see where.
Well, let me ask the judge. Your Honor. Okay, that's all, Thomas. Thank you.
All right. Thank
Bye.
you. Bye-bye.
Okay, so I'll find that the card you displayed is just the automatic renewal card that comes in. Coincidentally, it renewed the day after you got stopped, so I'll go ahead and buy that. Dismiss the ticket. I'll turn that to you. And then you asked me about your criminal charges. They were dismissed without prejudice. Now, without prejudice means they can be refiled. So it's up to the prosecutor to decide whether they're going to refile them.
I prepared something for the court.
Without the prosecutor here, I can't make any decisions. I'll just share some general thoughts with you because I see you've got a subsequent driving suspended ticket out of, looks like Tumwater. So you have a court date, I believe, in August on that. Let me check. So my guess is, since you have a new charge right away, that they may not be willing to dismiss the new charge, and they may resurface the old charge because, as I said, it was dismissed without prejudice, which means it can't be refiled. So right now you're scheduled for court on the Tumwater driving suspended charge on the 5th of August at 1:30 in the afternoon. So that's a Tuesday at 1:30. We're doing court. So without ruling on anything that might be filed on the new case, I'll just share some thoughts with you, which are that the view that you set forth in your pleadings is, we see that occasionally, very similar language. I don't know, sometimes the briefs we get in this line are all read the exact same. Yours is not the exact same, but a lot of language, exact same. There is no case in the country that says a state cannot regulate the driving, both commercial and private, on any public thoroughfare. So, I read your arguments as to why you believe the freedom of travel means you can drive your private vehicle on public roads, which are paid for by the registration of the vehicle, by the way, in part. That you believe you can drive because you have the constitutional right to travel. That it's never been interpreted that way. So the constitutional right to travel does not apply to overcome the requirements that states have imposed to require you to register your vehicle on an annual basis. That is it. I pay my registration fees every year because I have to, in order, if I want to put my car on the road. And I know if I put my car on the road with expired tabs, I'm going to get stopped and I'll have to pay the fine and I'll have to go get my car tabbed. I just know that's the way it works. And that's how the system is set up. So there's no legal argument there. You made it in a sort of a big way, but I think it's a misinterpretation of what you believe the right to travel is. It does not give you the right to travel in any state not adhering to that state's laws, and every state has a registration law like the state of Washington. So you've asked for my general.
Have you noticed that in courts, a car is referred to as a motor vehicle? A friend riding with you in the car is referred to as a passenger. You're engaged in traffic, and what the problem is, when a person registers his private property automobile with the state, he's declaring it a commercial vehicle.
No, that's your interpretation, and I'll just tell you that's not the interpretation shared by the courts. We don't see it that way at all. So the law makes very clear that all of us who have vehicles that we put on our roads, they have to be registered. Doesn't matter whether we have passengers, no passengers, if we drive them ourselves or not, if we're engaged solely in personal business or moving from point A to point B, none of that exempts us from the requirement to appropriately register our vehicles, which is used as a means of supporting the construction of the roads that we drive on.
Yeah, you know what? You said you've seen a few of these. What compels people to do this is the state abusing its power to license drivers, as well as doctors and other professionals. If you don't behave the way the state wants you to in your private life, in your family life, the state, through the family court, can have your license suspended. And that's just strong evidence that the system is not set up to make the road safe, but to control people. And people don't like that.
Yeah, I understand the philosophy behind that. We don't do anything here with suspending licenses or not. We just interpret whether the person has a license or doesn't have a license. That's the only rule of the court there. Now, I will say what you're referring to is the ability of the Department of Licensing to suspend licenses for the failure to pay child support as
It's
ordered.
government support.
What's that?
It's not child support, it's government support.
Okay, well, it's called child support. And that's what it's, if you look on your driving record, you have one of those things there that says, it says failure to pay child support. I understand there's a different way of looking at it. But it is not directly related to driving. I get that, but the legislature made that. They thought, how can we leverage people to pay what a court has determined they should pay for the support of their children. And they decided that one good way to do it was to leverage the ability to drive. So that's what the legislature decided to do. They created the law. Nobody has determined that law is unconstitutional.
A lot of people have, but they haven't taken it.
Right.
So in family court, the court rules don't apply. You know that. And due process is streamlined. So your driver's license can be suspended through a court procedure where it's a free-for-all. I've seen it.
Okay. Yeah. So I like I said, I understand the philosophy you're indicating. When the case comes to me on a driving suspended charge, I look to see if your license is active or if you don't have the privilege to drive on the state. And you view it as a right. The law views it as a privilege, and the privilege is enacted if you are properly registered and insured.
Well, it's a privilege to operate a motor vehicle on the highways, but the courts have ruled, and it's in my brief, it's a right to travel by your automobile, by your private property automobile.
No, there's no court. Like I said, you can look all you want, but nobody has ever found a case that says a court upheld the ability of somebody to drive in whatever state on public roads.
Well, driving is a commercial term too.
Okay. To operate a motor vehicle in any regard.
That's even more a commercial term. Look at it.
To operate your car. No, there's no case that says you can operate your
means
car.
using a business machine on a public utility.
No, that doesn't. Operate means I'm operating my computer. I'm operating.
That's a colloquial.
My pencil.
That's a colloquial term.
Well, then you're pushing your example into sort
Look
of.
at Black's 5th edition. You'll see that operate means using a business machine for gain.
Okay. I disagree with that, and I don't think you'll find any case that supports that.
Okay, so, I appreciate your input.
All right.
Thank you.
Mr. Blatt, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
But first of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
last name is Kidmacher.
Okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
right.
The bond is equal to the insurance that a driver would need to have.
So I do have a oath of office. It's good. The auditor's office. If you want to go there and get it, you can certainly look at it. But like I say, I don't carry it with me. I don't have it on the. I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't. We're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now, at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes. So
I don't agree with your terminology there in terms of what they franchise. So Tumwater is a municipality. They have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this. Not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the third degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies that obviously would be under the revised code of Washington, and that would go to Superior Court. But this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
Are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. Again, don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the third degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. A passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the revised code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all that's things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or go to, you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And we can have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county, and it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
yeah,
right?
Typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judge is to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
Okay.
And I'm going to bring up to the jury the issues of law. My question to the court is how would
here in a second, I'm going to stop you for a second. You're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury is going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court, and that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave because it's at 2:30 and we have some other people coming on at 2:30. We're going to take care of those cases and then I'll come back and speak with you some more. All right.
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts. And basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts. And I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Well, that's a good question. I guess you'll find out if you take this to trial. But we're going to stop for a minute. I'm going to there's a couple people who we're going to take these cases, and then we'll come back to you. But don't leave.
Docket does not reflect a pro se colloquy having.
Okay, yeah, we'll talk about that.
Thank you.
Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Okay. Well, again, that's what everybody wants. So do I. But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. You were making a distinction between jury trial and trial by jury. And I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. Basically, it was a trial by jury. Now it's a jury trial where the jury's neutered. There's only 6 of them. They're cut in half, and they're not allowed to. They're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so, Mike, those are your 2 options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
No.
Well,
I mean, you're under you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to, let you know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No,
plaintiff-
absolutely not. I don't know why you would think that. That's completely not true.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him. He would lose.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether, or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because Washington.
Well, the city of Tumwater in this case, remember we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they can still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney or have one with you or go it alone?
I'm not sure I need an attorney at this point because we'll have to see.
So again, that's a binary choice. So then from that, I can tell you you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
Just look at my record.
That's, again, I can see your record, but that none of it tells me whether or not you've done a trial by yourself before. So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So then I'm going to talk, and then we're going to set a date, and then we'll conclude the hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution at Article 1, Section 1 states that when the state is a party, which is this case, excuse me. Let me get the glasses. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.
So, again, I'm going to speak for a few minutes, and then I'm going to turn it back to you, and we're going to set a date here. And again, I don't... First of all, this case is headed for trial. And again, it doesn't appear that you're interested in having an attorney appointed to represent you, so you'll be going it alone. When you have the constitutional right to do that, but you need to know that you're not an attorney. Apparently, you have very low opinion of attorneys generally, and a very low opinion of the system itself. Could you tell Mr.
I have no problem with the law.
Hang on, let me finish. I'm not done yet. The city of Tumwater is going to be represented, and I know you don't like that term either, by an attorney. That attorney is trained in the rules of evidence, trained in the rules of procedure, been through trial many times. And again, I don't know whether you have or not. And so they are experienced in the rules of evidence, which is important. You spoke disparagingly of the rules of evidence earlier. And they have training in that, which again is important. And I'm going to assume you don't. And many of the things that you've talked about, you're incorrect on. Unfortunately, you're just incorrect about some things. And so you're going to be at a big disadvantage when you go to trial without an attorney going it alone. Do you understand this?
Isn't it the prosecutor's job to decide whether I'm wrong on issues? You're supposed to be neutral. The prosecutor hasn't even argued against me, and you're already saying that I'm wrong.
No, I'm trying to, believe it or not, and you probably won't, I'm actually trying to help you, let you know that this is just the way things are going. This is the way that this will happen. I'm not siding with the prosecutor. I'm just saying that this is what, and it's not the prosecutor's job really to decide what the prosecutor and defense, they disagree all the time on what the law is or what should be. And then I'm the one who gets to decide one way or the other. But some of the things that you're saying are so outside the norm that I don't need to hear from them. And I'm trying to let you know that what you think is going to happen and what you think the way things work is simply just not correct. And, I'll go back to that fundamental, I can't speak to the way juries were back in the 19th century. I just know how they are now. And I know that the jury's job in the cases of this sort is to find facts. That's what it is. And the judge is going to instruct them on the law. That's how it is. And the judge is going to determine what's going to be admissible or what's not. And that's just the way the trial is going to go. And I'm trying to let you know that is just to give you advance warning. So when you're in the middle of a trial saying, hey, what's going on here? You just at least have an idea of what's coming. That's all I'm trying to do. And I want to make sure that if you go to trial alone, you're going in with open eyes, understanding that you're at a fairly huge disadvantage. And so, but knowing all that, that's still the avenue you want to take.
You said the jury's job is to decide the facts, but there's no facts to decide because I'm acknowledging all the facts. I'm acknowledging all the facts. I'm not going to challenge them. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about. My issue is the law. And I'm not saying the law is wrong. It's a question of whether the law, this particular law that I'm charged under, applies to me, whether I'm a person within the meaning of the statute. Now, the jurors are taxed to pay legislators to make up laws for their benefit, yet they're not allowed to know what the laws are. Don't you think there's something wrong with that?
Well, I guess my response to that is, I think most people are aware that when you get behind the wheel of an automobile and conduct it in traffic, you need a license. And there are certain things that can happen that can get your license suspended. I think most people know that.
Well, my position is I never had a license, never applied for a license, and I was not engaged in traffic. I was engaged in travel. Traffic is going to be the issue at this trial. And
well, it'll be up to the jury it'll be jury to determine whether you were in traffic or traveling. That's excellent. And the issue that you said, well, I never had a license, so it couldn't be suspended. I've seen people try this before, and I've never seen it work. License. So here's what we're going to have. Hang on just a second. Here's what we're going to do today. So right now, trial is set for October 29th and 30th. Jury confirmation is set for October 22nd. You said you had a motion you want to bring. That'll be heard on, what do we do? Yeah. That'll be heard on October 20th. You need to have that filed in writing by October 6th. And the state will have their response filed by October 13th.
Your Honor, if we could please request the defendant's email address so that the response motion can be sent to him as he's not per se.
Did you hear that, Mr. Blatt?
Not really.
They want it because so you're going to file something, and they're going to see it. They should have the opportunity to respond to it, and they want to get their response to you, and they want to do that through email.
That's fine.
So what is your email?
At yahoo.com. BLATT.
Did you get that?
I did, thank you.
All right, Mr. Blatt, I think that's it for today. And then at that particular time, the judge, whether it's me, whether it's one of the other judges here, I don't know.
How many judges work in this court that could be on this case?
4.
4, okay. Can I have their names?
Sure. There's Kayla Wilcox, Brett Buckley. You already know my name. And then there's a commissioner named Paul Wool. It's all on the district court website. You can just go look at it.
Okay. Thank you.
And my guess is that judge, whoever hears the motion, is probably going to have a conversation with you again, or at least try to, about the concept of representing yourself and the disadvantage. And again, I know you hate that word. I'm sorry if that offends you in some way, but or going to trial alone without the assistance of an attorney. That's just.
I never expressed hate for any statute or attorney or wording or the.
I don't say that. Again, I'm not suggesting you are. I think that, or if I did use that term, I apologize. I just think that, I'm spending a lot of time with this because I just think you're under some misunderstandings of a lot of real basic points. And, in terms of we're here in district court, the state of Washington, you want to talk a little constitutional law, state of Washington Constitution sets superior courts of records. It's also in the Constitution that they can set and create such inferior courts as, by statute through the legislature. The legislature has done that. They have established this level of court through Chapter 3 in the Revised Code of Washington, if you want to look there. There's also a mechanism in place where district courts can contract with municipalities to provide court services. All this stuff has been litigated through the Court of Appeals and the Washington State Supreme Court. And again, it's just pretty standard stuff. And I've tried to spend some time explaining it to you. Unfortunately, I don't think I've been very successful. I'm sorry about that. I wish I was more successful, but you can research all that out. And I guess when you talk about one thing I will go back to that I should have said earlier, when you say the jury, you want to argue the law to the jury and shouldn't they know the law and so forth. A lot of that happens in the Court of Appeals and the Washington State Supreme Court. Again, I'll instruct the jury or whoever the judge is, whether it's me or one of my colleagues, will instruct the jury on the law. The jury will decide the facts and then apply the law as I instruct them to it. Now, if I'm wrong about the law and you turn out to be right, all that's handled at the appellate level. You would file an appeal if you're convicted, and then you would, the court, first superior court would look at it and see if I made a mistake on the law, or you're right on the law, and then it keeps going up all the way to the Court of Appeals, and then eventually to the Washington State Supreme Court, all they may or may not choose to take it. And so that's where the issues of law are decided.
Everything you just said about the evolution of the law is true. However, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary for a free state. That's what it says. So that means we eventually get so convoluted to oppress citizens of the state that we have to go back to fundamental principles.
Right. And again, I do want to address your last thing, in terms of oppression. Again, let's remember what we're talking about here. And that is your license was suspended and you were alleged to have been driving. I know you have to say, well, you were traveling or whatever. And that's just, again, the only issue is, were you conducting an automobile and was your license suspended? And that's it. That's what this case is all about.
An automobile is different from a motor vehicle, and I believe the statute refers to motor vehicles. Motor vehicles encompass a lot of things. A motor vehicle can be a motorcycle, it can be an automobile, it can be and I think that that's generally pretty accepted that an automobile is a motor vehicle. No, I
believe that it is.
A motor vehicle,
unless it runs by. Unless it's the Flintstones where they just run on the ground, then it's not a motor vehicle, but I'm joking, perhaps I shouldn't be.
A motor vehicle is a specific legal term in commerce. It's a business machine, like a truck, a taxi, or a bus that makes its business on the publicly funded roadways, which it does not have a right to do. A person
again, in Washington, and again, a motor vehicle includes a car. It does. And again, where do you get your driver's license? You go to the Department of Motor Vehicles, the DMV. That's where you get a driver's license for cars. And
Well,
so
when
it
you-
makes sense and again, I don't want to, we're going down a rabbit hole that was really not productive for either one of us, frankly. But, and again, I will just tell you that a motor vehicle includes automobiles within the terms of this statute in this state. It just does. And you can argue
I'll address this in my brief.
otherwise, but you're not going to be successful.
I'll address this in my briefs and my motions, but of course, the prosecutor and you will just pretend like you haven't even read it, like it. I've been through this many
No, I
times.
can't speak. Okay, I'm going to stop you again. I won't speak for the prosecutor, but if it's me, I'll read it. I'll read all of it.
But my experience has been, I'm sorry to say, to accuse you, but my experience has been that judges will just pretend that they haven't read it. They'll say, I've read it and I found it's not correct. But they never talk about the issues.
Again, I don't want to talk about things that haven't even happened yet. So maybe it'll be me, and then we'll see what happens. But do you know when you need to get your brief due?
By October 6th. October 6th, and the response by October 13th.
And we'll all reconvene on October 20th and hash it all out. Whether it's me or one of my colleagues, I don't know.
Okay.
That'll conclude the hearing for today.
Thank you.
You're welcome.
So.
Mr. Blatt, was Mr. Blatt here?
Who's here for court?
Then we may as well.
Thank you.
Yes, Mr. Blatt is here.
Oh, are you Wingtip TMRV?
I don't know what that is.
I don't either, but that's what you're identified for on the Zoom call. A lot of people can put their name in there, so I know who I'm talking to. Yours just says Wingtech TMRV.
This is really the first time I've used Zoom. I'm not familiar with it.
Okay, well, can you activate your camera so I can see you?
I'm trying to. This is a new phone, so I'm not familiar with it. I can't see anything where to activate the camera.
Go down in the lower left. There you've changed it. Oh, did you do that? Okay.
To start my video.
So on the lower left screen, you should have a little, there, I think you're going to come on here in a second. Yeah, there you are.
You see me?
Hi there.
Okay, I don't see me, but...
I see you. And did you mute him? No.
No, I didn't mute him.
Okay, so I need you to unmute, Mr. Blatt. Click on your microphone. Mr. Blatt, in the lower left corner, there's going to be a little silhouette of a microphone with a line through it. You need to click on that. I can't hear you until you do that. I can't hear you. You've muted your microphone. You need to unmute it.
Okay, can you hear me now?
Yes, I'd like to be able to do both, hear you and see you.
Can you see me? Can you hear me?
I cannot hear you. I can hear you, but I cannot see you. I heard that.
Sorry.
There you are.
Okay, can you hear me?
I can. Can you hear me?
Yes.
Perfect, and I can see you, so don't change a thing.
All right, I won't touch it.
So there's a motion on the calendar here. You're representing yourself, correct?
I am myself. I'm in
know.
propria persona.
I'm sorry?
I'm in propria persona.
Okay, well, in any case, you don't have an attorney and you'll be running your own defense. Is that what you're telling me?
Yes.
Okay, and so the state's asked to, there's just a state, the city of Tumwater is asking to continue the trial. Did you see that motion?
No. But I'll take your word for it.
Thank you. But I will tell you what the substance of the motion is.
I have to explain if you missed the last hearing. I was poisoned by insecticide. I bought anti-flea spray for my dog and it said non-toxic on it. So I sprayed it all over the house and my bed and my clothes and it knocked me out for 2 weeks and I still lose my balance sometimes. It was really poison.
Okay. I'm sorry to hear that. But here's where we're at on the trial. The state filed a motion. Let's see, right now, trial is set for confirmation is October 22nd in 2 days. And then the trial is set for October 29th and 30th. The state's asking to move that because they have a witness issue. One of the police officer apparently is not available on that time. And so they want to move the trial maybe a week or two. And I guess I would get your position on that request.
Well, what'll happen if I decline that, if I object to it?
Well, then they're asking, then I get to decide whether or not the state has shown good cause to continue the trial or not. And then one of two things can happen, I guess. I can, you're objecting, I can sustain your objection, not continue the trial, and then the state would probably be out of luck. Or I could find good cause because a material witness is unavailable, and then I can go a little bit beyond when speedy trial is to allow the trial to take place with the state's witness. And I can tell you a couple of things. One thing that this is a fairly common occurrence from both the defense and the state. And if a defense comes to me and says, hey, look, I need these witnesses to defend my case, but they're not available, can we move the trial? I'll generally accommodate that. I'll let people put on their defense. But the same is true for the state. If they have a witness, and I think who is material to their case, and they can't proceed without, I'll give the state some leeway to find good cause and reset the trial to when the witness can appear. So that might be a spoiler alert, but it's up to you. You don't have to agree. No one's asking you that. I'm just asking, I'm telling you what the state's asking. I'm telling you what generally happens in situations like this. And I'm just asking for your response, and then I'll make a ruling.
Okay, if you deny the prosecution's request, then the trial would be held in 2 days?
No, the trial, I don't know what would happen if they denied the state's request. Then if the state can't proceed, they can't. But I think I kind of hinted that generally I grant this type of motion, but because I want to be upfront with you. But it's up to you as to how you want to decide.
Well, I object to their motion.
All right. I'm going to find good cause to continue the trial because of the state's unavailability of a state's witness. I'm going to ask Ms. Kidmacher when's the soonest available date that you can be ready and have a trial, and I'll set it for that date.
Your Honor, my understanding is the officer is unavailable through November 8th. Other than that, I don't have notes as to other unavailable dates.
So what we're going to do then, Mr. Blatt, we're going to set the trial for November 17th and 18th, and then we'll have confirmation on, let me put these on November 12th, which is a Wednesday at the afternoon.
May I ask something?
Yes.
As I understand, the hearing I missed was the motions hearing, right?
No, this is the motion hearing.
Okay, I'm not prepared because, as I said, I was sick and I'm still recovering.
No, but the motion is, hang on just a second. The motion is to continue the trial. And I've already asked you what your response to that is.
Oh, so it's the prosecution's motion, but I also, didn't I also notice a motion hearing?
Okay, we can renote that if you want. I didn't see that. That's not what I'm here for here today. When did you ask for that motion hearing to be held? Oh, I see.
Your Honor, at the hearing back on September 3rd, I see a note for a motion hearing set for today. Defendant must file his motion no later than October 6th. And
well, that was me. Yeah, did you ever file anything?
I don't think so because, like I said,
you were sick. I get it. Yeah, all right. Well, you're still free to. Well, do you want that motion heard?
Yes, please. But I'm not.
You better file it. I mean, you were supposed to file something by October 8th. We didn't get anything.
Right. Can we reset that and the deadline for me to submit the motions?
Yes, we can do that, but we'll probably, in order to accommodate that, we're going to have to move this trial out a little bit further.
Okay, past the speedy date?
Yes, it's already past the speedy date based on my finding of good cause because of the state's material witness unavailability. I can, your request, if you want your motion heard before that, I'll accommodate that, but we're going to have to mess with the dates a little bit.
Okay, I'll waive speedy trial rights for that.
Okay. Well, I don't even think we need to get there. I can make findings. Okay, so let's forget those dates. Let me redo these dates here. Well, let me ask you, how are you feeling now? How quickly can you get your motion together?
I'm doing okay. Like I said, I lose my balance sometimes, but I'm getting better.
I'm just asking you for a time limit. How much time do you need? I'll give you the time you need. I just want to know how much you need.
1 week.
Huh? All right.
1 week.
So hang on just today. Let me take a look here.
And Your Honor, I'm not sure what type of motion or whether it's going to be something that requires officer testimony. So I would just ask that it be.
My guess is if it's constitutional grounds, and if you need officer testimony, you can ask to reset it. But I
would ask that it be set after November 8th.
All right. Because the officers need to be present. All right. So we're going to set a motion hearing for November 10th. All right.
Yes.
You need to have your motion filed by October 27th. It's a week from today. So you have a week to get your motion together. Get it filed by October 27th. The state needs to get their response in by November 3rd. And then the motion will be heard on November 10th. Why don't we just do a confirmation for that date also? And then I already moved the trial date to November 17th and 18th. We'll just leave that date. And then the confirmation will be the same as the motion hearing date on November 10th. And if he's successful, then we'll do it that way.
And you said trial 17th and 18th.
What's that? 17th and 18th. Thank you. Okay, so do you understand where we're at?
Yes.
When do you need to have your motion filed by?
The 27th, 1 week.
Right. And then the state by the 3rd. We'll see everybody back here on the 10th.
Okay. Thank you.
Hang on just a second. I have another question for you. Have you been getting text reminders of court dates?
Yes.
Great. We'll see you back here. And then this will be excluded from speedy trial calculation. I'll make that finding based on the witness unavailability and to accommodate Mr. Blatt's ability to get his motion in. Understand all that, Mr. Blatt?
Yes.
You're free to go.
Okay, thank you.
Sure.
All right, next we have Leonard Blatt. Morning, Mr. Blatt.
Morning. Pleasure to be here.
Mr. Blatt, you filed various motions to dismiss the driving with suspended license 3rd degree against you. I've read all of it. You know, we are getting kind of late in the morning here. Is there anything you'd like to say that is different from what, or that you'd like to highlight from the motions that you filed?
Well, first, may I ask the court to identify yourself and the prosecutor?
Certainly. I'm Court Commissioner Jacob Stillwell.
Uh-huh.
And prosecutor today is Ford Libby, Rule 9, supervised by Rosemary Fitzgerald.
Okay. Yes. When the officer stopped me, he asked me for paperwork and simply accused me of a paperwork violation. He asked for 3 things: license, proof of insurance, and registration. Anyone who's engaged in a potentially hazardous activity like operating a motor vehicle has to have his paperwork in order, especially insurance, because he can cause damage with his car. Excuse me. Same thing is true with yourself, because being a judge is a potentially hazardous occupation because it involves violence. No one can be put in a jail cell without unwanted touching. And a lot of damage can come to people if a judge does something wrong. And as a person who has been through a family court and witnessed how unprofessional and out of control the judiciary is here in Washington, and I think you know that the reputation of the legal system in Washington is very bad. I mean, even at one point, the federal government had to come in and supervise and babysit the police because they weren't being controlled.
So I'm going to just try to frame what I'm looking for. Because again, I did read what you briefed. And so maybe it would be helpful if sort of I outline my thinking here. I'll give you a chance to respond. I'll give the chance for the city of Tumwater as well to weigh in here. But let me just kind of start where I'm at. That sounds good.
Sure.
Okay. All right. Because I know a lot of your arguments are sort of based on sort of overall authority to enforce these laws against you. So I'll sort of start there. Right. The revised Code of Washington, which is the state legal code that is applicable here to criminal offenses related to driver's license. It provides that RCW 4620-342, that it's unlawful for anyone to drive a motor vehicle in the state while the person has a suspended or revoked driver's license. The allegations against you is that you were driving a motor vehicle on a public road with a suspended driver's license. And those are still allegations against you. That hasn't been proven. But the city of Tumwater is within its authority to pursue that prosecution because you were allegedly driving a car with a suspended license. And so I know you've raised a number of concerns around that. One of them being, right to travel. You have the right to travel. You don't have a right in any particular mode of travel. So driving a car does trigger certain legal requirements.
Excuse me. I've been in this court already, I think this is the 5th time, and each time I've heard the judge make the arguments that the prosecutor is supposed to make. In other words, the judge has been prosecuting. May I get back on track, because I was making a point. I was heading toward a point when you asked to interject.
Sure.
Okay, so we need to take care of some preliminary matters first. Just as I had to produce paperwork when an officer saw me what he believed to be engaged in privileged activity, you need your paperwork in order too. And I just need to verify that your paperwork is in order. I am eager to argue my motions, and I'm eager to hear the prosecutor's response. But first, we need to know if you have your license to operate, which is your oath of office. That's analogous to a driver's license. It's because nobody has a right to be a judge. It's a privilege. And also your bond, your official bond through a surety company is analogous to an insurance for a driver. Because if I'm injured in the course of these proceedings, I need to know that I can be compensated. So
you're welcome to file a public records request asking for any documentation around my authority as the court commissioner or anyone else in the.
Right, and I couldn't do that because I didn't know who would appear today as a judge. I mean, I asked before and I couldn't get a clear answer. Also, your bond is supposed to be filed with the county clerk. And with your permission, I mean, I want to make it easy for you. Don't want to make you produce it for me. I could go around the corner, it's in the same building here, and verify that your bond is filed with sufficient sureties.
So we're not going to do that today for relevancy purposes here, because what's relevant here is not anything related to me. It's related to allegations against you driving.
It absolutely is relevant to you, because it's all about whether you have jurisdiction, and you don't have jurisdiction without your oath of office timely filed and a bond with sufficient sureties. And I have a pocket brief here that I'll give you the court and a copy to the prosecutor to show you.
I'm going to stop you again, and I don't mean to interrupt here, but you have the opportunity to look at those documents. If you're able to find documents in any way, indicating that we don't have the proper authority or to operate as a court in this case, you're welcome to get those documents and present them. But we're not, during the course of the prosecution, going to chase down every indication without any supported evidence that something's amiss here. So if you have something through a public records request, you're able to bring it, but we're not going to chase down all of those arguments as they pop up. We're not going to play whack-a-mole necessarily with arguments being made without evidence.
So if I've told the officer who stopped me that I have a driver's license, I have insurance, trust me, it's your job to go look for it, not mine to produce it, what do you think he would have done?
Well, I don't know. I wasn't there.
Well, we all know what he would have done. He would have said, that don't cut it.
So these are all comments that you made in your briefing. So I'm going to, again, remind you, I've read those arguments that you made.
I'm going to give a copy of my pocket brief showing that the judge and prosecutor both require bonding and insurance. And with your permission.
And if you have evidence that there hasn't been proper bonding, you can certainly bring it.
Well, that's my evidence, my testimony here.
Right. Well, you're not alleging it hasn't happened.
I am alleging it hasn't happened. I am alleging that. With your permission, I'll give the court a copy of the pocket brief I just gave to the prosecutor.
Sure. But then I'm going to turn it over to the prosecutor to have an opportunity to respond.
Isn't it my turn to present my motions?
Yes, and you have.
No, I have not.
You have. You've provided written motions You've been given some time to sort of summarize what your arguments are here. So we also want to hear from both sides.
I need to make a statement for the record so the appellate court can understand.
Well, it's 11:33. You got till 11:40. And I'm going to turn it over to the city attorney.
Well, if the prosecutor wants you to take 3 months out of my life, you have to give me enough time because the taxpayers are going to pay for this. You see, when the officer first stopped me, it was mistakenly thought that I would pay the $66 fine or however how much it is. And what's going to happen is the opposite. The plaintiff is going to house me, clothe me, feed me, take care of all my needs, medical needs and everything. And I'll get to watch television. I love to watch television. And I love to kick back and relax. And that's what's ultimately going to happen. But we're going to go through due process first. I won't be denied due process. So every district judge, this is RCW 3.34.080. Every district judge pro tempore, and district court commissioner shall, before entering upon the duties of office, take an oath to support the Constitution of the United States and the Constitution of the State of Washington. And as far as bonds, every judge of a municipal court, before entering upon the duties of office, shall take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Washington. The judge shall also give such bonds to the state and city for the faithful performance of the judge's duties as may be by law, ordinance, or directed. The prosecutor's bond, every county official, before he or enters upon the duties of his or her office, shall furnish a bond condition that he will faithfully perform the duties of his or her office. Prosecuting attorney shall file it in the amount of $5,000 with sureties to be approved by the proper county legislative authority. Tumwater police officers also have to have a bond, and that's RCW 35A.12.080. As far as, so it's very, very important. It's not just a joke or something that's not important. It's very important that you have an oath of office on file, because from what I've observed in this court and many, many courts throughout the last 40 years living in this state, that judges hate to follow the Constitution. They despise it. So I need to ascertain that you have a timely filed oath of office. Now, I did make a public disclosure request for all the judges that might be operating in this court, and I have them here. I want to make sure your name is on it. I have an oath of office for a John Tunheim. It's not you, right?
Remind you to, you've got till 11:40. It's 11:36.
What if it takes longer?
Because sir, I'm telling you again, I've read what you've written, and you're frankly not making arguments that are relevant to your prosecution. So you're allowed to speak, but if you have evidence and if you have evidence there that you wanted to present to the court, you should look at it beforehand and then make an allegation.
I did.
Well, you're reading through the response to your Public Records Act.
You said I should make a public disclosure request for your oath of office and bond, and that's what I've done. And here I'm going through it.
Right, you should go through it before the hearing.
Well, I didn't know who you were until I just sat down here.
Well,
I didn't know who the prosecutor was.
Your Honor, I don't want to belabor the point, but just to make sure that we're being as effective as possible here, this just falls outside of the scope of today's hearing.
I know.
No, it does not, because my brief addresses the importance of obeying the Constitution of the United States and the state of Washington.
And I can tell you, I have my oath of office. I took it a couple of weeks ago. Granted, I'm newer here, but I took it in this very room.
Well, I could not find it unless it's here, because I was given all the oaths of every judge that could possibly be working here. That's what I requested. I also have an oath of office for, it's John Tunham again. He gave me a few. As far as bonds,
just so you know.
As far as bonds, Joel L. LaPierre is supposed to have a bond. That's not you, though, right? What is your bonding number?
I don't know. Top of my head.
Okay, so before we can proceed, we have to take care of this preliminary matter.
That's not true.
Well,
You are welcome to bring evidence that I'm not a correct judicial officer for this, but again, we're not going to play whack-a-mole.
well, you're supposed to prove it to me, just like I was supposed to prove it to the officer that stopped me, that my paperwork was in order before engaging in a privileged activity.
I certainly believe that, but that's not the law.
You don't, can you cite the law then?
No, you're asking me to cite a law that doesn't exist. A judicial officer does not need to present their bonding number to every defendant.
But you need to have a bonding number, and we've determined that you don't. I requested the bonding information and the oaths of office of every judicial officer that could be working in this court, and they gave it to me all here, but your name doesn't appear to be on it.
Well,
That's prima facie evidence that you don't have an oath of office or bond.
okay, well, then you can file a motion on that specific question if you'd like, but you've got 2 more minutes for this morning.
Okay, I'd like to file that motion right now.
You don't have it. You got to go file a motion.
I can make a verbal motion. I can make it orally. Do you want me to find the RCW, the statute that allows me to make it orally?
Sure, and then you can go and you'd have to, well, I can't give you legal advice, but.
You gave me a lot of legal advice
I'm
today.
explaining what the law is.
The prosecutor said nary a word.
You got 1 more, well, because we've been giving you a chance to speak, and you've got 1 more minute before we're turning it over to the prosecutor.
Well, I have to determine whether we have jurisdiction here.
No, that's not up to you.
Well, it's up to you, but you're not making a decision on it.
Because we do have jurisdiction. I'm telling you, I have an oath of office.
But that's not enough. Me telling the police officer I have a driver's license is not enough.
The allegations that you did not have a valid driver's license.
Yeah, a surgeon telling his licensing authority, I have a license, without proving it is not enough. We have prima facie evidence here that you don't have an oath of office or bonding. And the Constitution, you say you have an oath of office? Well, that means you swore to uphold the Constitution. And the Constitution requires you to have an oath of office timely filed. And RCW Title 42 says if you don't have it timely filed, you're not lawfully in office. That means that you can't preside over this hearing.
And to the extent you want an answer right now, I'm denying that motion. If you want to file something in writing that goes into that in more detail and provides some kind of evidence that I don't have authority, you're able to do that. I don't know when you made your public records request. It might have been before I took my oath of office, but we're out of time for your arguments.
How do you spell your name?
S-T-I.
S-T-I.
L-L.
L-L.
W-E.
W-E.
L-L.
L-L.
First name Jacob with a C.
Okay. I'm going to not participate in an unlawful hearing. So I'm going to go over to the clerk's office and try to get your oath of office and bond. And if they have it, I'll be back here and let's proceed. I'm actually eager to do so.
Well, we're going to have to file a motion. We're not going to probably be here anymore when we come back. We close up at noon.
You don't operate after lunchtime at all?
No, the calendar is going to end at noon. So if you find something, you can file a motion, but we're not going to stay open just so you can go do your public records.
Okay. Well, I came here at 9 o'clock because I thought things would start then, and I had to endure watching all this.
Sir, we're out of time at this point.
So that's what I'm going to do, because I'm not going to participate in an unfair hearing where there's no jurisdiction. I will file another motion.
Final comments here, because we got to move on.
My final comments are this. We're going to assume that you don't have an oath of office timely filed or bonding, so you can't proceed over this hearing.
You can
It's
go get
simple.
evidence of that. You can come back, but until then, we're going to, unless the prosecutor has anything to say.
Okay, so then since I object.
Sir, I'm moving it over to the prosecutor.
So since I'm wait, I have a right to make my motions. I have a right to argue my motions. I brought this hearing,
I understand.
not the
We're going to
prosecutor.
move on.
I brought this hearing, not the prosecutor.
We're going to move on.
So I'm going to ask you to recuse yourself since you're not well.
All right, well, if there's been a request for recusal, perhaps I won't be here at the next hearing, but that's going to be it for today, okay? Free to go. Well, sir, we're also here set for trial confirmation. You have a jury trial set.
I haven't even asked for a plea yet.
Well, you don't have to. I mean, the state is moving forward. Probable cause has been found. You've elected to represent yourself against.
I am myself. I don't represent myself. I am myself.
Well, are you ready to proceed to trial on November 17th?
First, I have to be advised of the nature and cause of action and enter a plea. And I have to verify that the judge, which keeps rotating, is lawfully in office. I mean, I'm not trying to throw monkey wrenches in this or anything or give you a hard time. I'm just trying to require due process.
You were arraigned on June 26, 2023. Determination of probable cause was found.
Your Honor, just to...
Well, you said I'm free to leave, and you're not lawfully in office, so I'm going to leave.
Well, Your Honor, if the defendant's going to walk out, I would request a bench warrant be issued if he's just going to walk out of his own trial confirmation.
Right, sir, are you here with him? Is that the two of you speaking?
I'm hard to hear.
I was asking if the two of you were here together.
I can't hear.
Were you here with Mr. Blatt?
I don't have a case here.
Okay, were you here with Mr. Blatt, who was just up here?
I can't really hear you. I'm getting a hearing.
Why are you here?
But I haven't had all the tests yet.
Okay. Why are you here in court today?
Oh, I'm just here to observe.
With Mr. Blatt?
Very interesting.
Okay.
I watched the body language.
Okay.
I watched the behavior panel on YouTube, and I'm watching this video to watch the body language.
All right. Thank you, sir. Okay. Thank you, sir.
Can I go now?
Free to go. Yes. Okay. All right. So the request is a bench warrant for. I don't know if I can issue a bench warrant for failure to appear if he doesn't show up for the jury trial.
Okay.
I think at that point there might be grounds, but.
Well, then I guess the state would just ask to keep the trial dates and proceed from there. And Your Honor, I believe you were clear, but just for the record, I know there's been a lot of talks about public records today. If we could just have a ruling on the defendant's motion today.
Yes, to the extent I wasn't clear, I'm denying the defendant's motions to dismiss all of that have been filed. And trial appears to have been confirmed. There's no unequivocal suggestion to the contrary. So we'll keep the jury trial dates as currently set.
Your Honor, the state would request that the court still order the panel at that. We would ask to go forward with the trial date at that time. If the defendant is not present for the trial date, the state would likely renew its motion for a warrant.
Right. That makes sense.
Thank you, Your Honor.
Hi. Well, that's just about it. So, thanks for watching. And we'll see you again real soon.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think.
Actually, I wish you could see the studio floor right now. There's nowhere more fascinating after a show. Everyone's so busy. like bees or white Anglo-Saxon Protestants.
And a huge thank you to all of our Facts or Frauds channel members. If you'd like to become a member, click on the link in the description or click join right next to subscribe.
There's electricians all rolling up their cables. Whoops! Sorry, guys. And there's the sound technicians unplugging all the microphones. Okay if I keep mine on for a minute, Nobby? Stand up.
Now, if you're still hanging out, thank you. I appreciate you all. Why not hit the thumbs up button, make sure you're subscribed, ring the bell, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.
And of course, there's lots of the producer's friends, all excited, waiting to meet the stars and generally getting in everybody's way. Just like our producer. Oh, we don't mind. Oh, and not forgetting the prop guys. They're busy striking the set. That's an interesting little point there. Striking. That's a word we all use in the biz for dismantling the set. Taking it apart, unscrewing things, releasing safety catches, that sort of thing.